Can applying for citizenship put you at risk? What if the very act of applying for U.S. citizenship could actually put your green card and your future in America at risk? Today, we break down who should apply confidently, who should wait, and who could face serious danger if they move forward without preparation. Why this matters now. For many permanent residents, naturalization represents stability, pride, and belonging. But in today's climate of stricter scrutiny, tougher interviews, and longer processing times, that dream sometimes comes with fear. Some residents delay applying, worried that one mistake in their past might resurface. Others even consider withdrawing applications, afraid that showing up to an interview could expose them to arrest. The truth is complex. Most green card holders remain strong candidates, but certain groups do face real risks. Denial does not always mean deportation. One of the most common fears is that if your application is denied, the next step is deportation. But in reality, that's not always true. Imagine someone who applies but has a minor traffic-related offense in their record. USCIS may conclude they haven't yet demonstrated 5 full years of good moral character. In that case, the application could be denied, but usually that's where it ends. No deportation order, no court case, just a pause. After completing 5 clean years, that applicant can reapply, this time with stronger evidence. For many, denial is not the end of the road, it's simply a delay. The 5-year rule and good moral character. The 5-year rule is not just about living in the U.S. continuously. It's about behavior. USCIS looks carefully at whether an applicant has demonstrated good moral character over the past 5 years. A single DUI, unpaid child support, or unresolved tax obligations can all impact eligibility. But the good news is that if those issues are resolved and enough time has passed, applicants often succeed the next time they apply. Low-level criminal records and old cases. Old or minor offenses, such as disorderly conduct, trespassing, or cases dismissed years ago, rarely create deportability issues. Someone with multiple arrests in their youth may still qualify if those incidents are far behind them and they've built a stable, responsible life since. Immigration law is designed to focus less on mistakes from decades ago and more on recent conduct and patterns of behavior. Many applicants with old charges have gone on to successfully naturalize once they've shown long-term rehabilitation. The real red flag: aggravated felonies. The true danger lies with aggravated felonies. Under federal immigration law, what counts as an aggravated felony is often broader than what a state might consider serious. Sometimes even misdemeanors under state law qualify. For those applicants, the risks are severe. If USCIS flags an aggravated felony, not only is naturalization denied, but a notice to appear in immigration court is often issued. In many cases, detention at the interview itself is mandatory, making release difficult and removal highly likely. For this group, professional legal counsel is essential before even considering filing. Real-life case study, a DUI example. Consider a lawful permanent resident in New York with a DUI from 10 years ago. Under state law, it was treated as a misdemeanor. Under immigration law, a single DUI without injuries or aggravating factors does not make someone deportable. However, it can raise questions about moral character. If probation ended in 2017, applying immediately in 2018 would have been risky. Waiting 5 years until 2022 shows a clean track record and greatly improves the chances of success. Timing matters just as much as documentation. Financial and family obligations matter. Beyond criminal records, USCIS also evaluates financial and family responsibilities. Failing to pay child support or alimony or ignoring tax obligations can weigh heavily against an applicant's case. However, setting up payment plans, providing proof of compliance, and showing responsibility can counterbalance past mistakes. The agency wants to see effort and accountability, not perfection. False claims and other red flags. One area where USCIS is extremely strict is false claims to U.S. citizenship. Even a single false statement on a job application or voter registration can create a lifetime barrier. Other sensitive issues include military service in certain foreign countries, political affiliations, or even prior membership in organizations that raise national security concerns. These situations require careful explanation and, often, legal representation. Why waiting too long can backfire. Many immigrants delay filing out of fear. But delaying can sometimes increase risk. Naturalization rules are getting tougher, not easier. New test requirements, expanded background checks, and stricter interpretations of moral character standards are being introduced. Applicants who once had strong cases may find themselves struggling under future policies. In recent months, several green card holders with old arrests who finally applied succeeded because they applied before new changes went into effect. For many, waiting is the bigger danger. Preparing before filing. Preparation is the foundation of a successful application. Anyone with an arrest history should obtain certified court records showing exactly how their cases ended. These are often inexpensive and easy to request, yet they make a huge difference in strengthening an application. Collecting tax documents, financial records, and proof of compliance with obligations is just as important. Having complete evidence ready before filing gives attorneys and USCIS officers a clear picture and reduces delays or suspicion. Citizenship beyond protection. One thing often overlooked is that citizenship is not only about avoiding deportation. It's about opportunities. U.S. citizens can vote, travel freely with a powerful passport, sponsor family members more easily, and access federal benefits and jobs unavailable to permanent residents. Citizenship turns uncertainty into security and opens doors for families for generations to come. When speaking with applicants over the years, one pattern stands out. Fear often keeps people from applying even when they have strong cases. Many spend years hesitating, worrying about what USCIS might uncover, while living with the constant anxiety of being just a permanent resident. Yet time and again, those who take the step forward, armed with preparation and legal advice, find that citizenship is within reach. The lesson is simple. Fear is not a strategy. Careful preparation, honest disclosure, and timely filing are. Final thoughts. Naturalization is not a simple formality, it's a turning point. For most green card holders with stable lives and no recent serious offenses, the risks are far lower than they fear. For those with aggravated felonies or ongoing legal issues, the risks are real, but with legal guidance, options may still exist. What matters most is timing, preparation, and the courage to act. In an era of tightening rules, waiting too long could be the greater mistake. That's today's breakdown. If you found this video helpful, please like, share, and subscribe to Visa Intel USA for real-time immigration updates and expert insights.